Just to set the stakes here, this is the most important case in United States history thus far having to do with the transgender issue and transgender rights. What's at stake here is one law, a state statute passed in Tennessee, but there are at least 20 plus other states that have similar laws. So you can see the scope of what we're talking about here. The fundamental argument, we're seeing this play out already in the initial questioning, is does this law, this Tennessee law, discriminate on the basis of sex or on the basis of age? And so the Solicitor General, who's arguing against the law on behalf of the Biden administration, the first thing she said to the court this morning is SB 1, the law, the Tennessee law, regulates by drawing sex-based lines. And the argument she's making is exactly what Paula just said. Under this law, if a boy wants to receive testosterone because he has growth issues or something like that, he can. But if a girl wants to receive testosterone as part of transitioning, she cannot. Hence, the argument is it discriminates on sex. The counter-argument, though, and Clarence Thomas was asking about this earlier, is, well, doesn't this law really just discriminate on the basis of age, which is permissible? We discriminate against children all the time. And the argument there that we'll hear from the Tennessee lawyer is, well, it simply says that children, boys or girls, cannot receive this type of medical care under these conditions.
And Seth, I mean, we're just showing a map of these bans across the country, and this is pretty widespread. I mean, that in and of itself makes this a landmark case. There are huge implications here.
Huge implications. This is going to ripple through all of the states, and about 26 states currently have a regulation that is comparable or similar to the one at issue in this case. I think that the level of emotion is higher than the level of complexity in this case. The core issue in this case is whether a state legislature has the ability to regulate gender transition care to kids. That is the issue. I understand that some states and some proponents consider this to be gender affirming, some states consider this to be gender transition, but I think that really cuts the point, because in the spirit of the Dobbs decision, the proponents of this statute would say that this gets the Washington health bureaucrats out of the treatment room, and it leaves it to the states to make a determination. And states have historically made not this level of controversy, but different kinds of regulatory health treatment for the body of kids historically for a century. Children are not allowed to have tattoos. Children can have guardians appointed to them if there's a serious question in the eyes of a judge as to whether the parent is delivering appropriate care to the child. Now, can reasonable people and state legislators differ? Absolutely. And there's no question that a decision in Minnesota and California is going to be different than in Alabama or Florida. But the pivot point in this case, and I agree, is going to be whether it is a distinction based on gender or a distinction based on age and delivery of medical treatment. And there's also an interesting question that you raised as to the weight of medical evidence. While many associations have come out in favor of this kind of care, there are several physicians in the record in this case which have testified and have submitted briefs to the Supreme Court talking about what they've seen at children's medical centers for this kind of treatment for kids that then come out on after they're 18 and say that they very much regret the decision. So highly controversial, major decision coming down by the Supreme Court.